Amit, I guess we can start now. It's 5. People keep
Sure.
joining.
Great. All right. Perfect. Okay, so you'll be logging it in now?
Yeah, Rupen is going to start recording.
Yeah, you can just let me know when to start.
You can start. It's already started.
Okay. Right. So good evening, everyone. Firstly, a big thank you to the NALSAR alumni cell for having me, and to Aditya Swaroop and Rupin Behel for putting this together. So essentially, the topic we're going to be talking today is the fundamentals of cross-examination. Now, two caveats to begin with. Cross-examination is an art that is as old as the profession itself. And this has, basically been an art form that's been cultivated over millennia, if not centuries. And it is something which learned through experience. It is something which is very dependent on instinct. So it is not very easy to theoretically expound about this subject. But having said that, because of the number of people who've done this over the years, some of our best legal brains, we do have certain good practices or best practices, if you might call it that, can be used as a general template for conducting a cross-examination. So a caveat at the outset, a lot of the rules which we today follow, I would not call them rules, best practices, are very contextual in the sense of the facts of your case and as also witness with which you are faced. Therefore, at the very outset, whatever I'm saying today, I will try and cover most eventualities. But ultimately, this is an art form that is best learned on the job. Secondly, a large part of what I will be speaking to you today will come primarily from a civil background, in the sense that most of my practice and therefore consequently my experience with cross-examination has been on the civil law side. And probably the only time I have engaged with a criminal law proceeding has been at the appellate stage. Therefore, that sort of bias in terms of my responses might creep in, though I am hopeful that most of these best practices which we look at will not really change in terms of whether they are emanating from a civil proceeding or from a criminal proceeding. Now, with that essential background in mind, I think we can just move on with the actual talk. Now, before I really start into the real meat of the controversy, one must understand the distinct role which the state of cross-examination plays in a case. Now, if you take the example of a civil law proceeding, you have the initial stage of pleadings, where essentially you put forth your case, whether in a written statement or a petition, or subsequently the defendant will do so in a print or a petition, and the defendant will do that subsequently through a written statement or a reply. Now, that is the stage when you actually articulate your case for the very first time. That articulation reaches culmination when you eventually address your oral submissions at the end of the case. When you try to make a distillate of your entire case, put it in the most convincing manner possible, and link facts to the applicable law, and essentially make out a case for yourself. Now, cross-examination comes somewhere in the middle. Now, cross-examination is crucial because this is the stage where you are essentially able to not only demolish the factual plank of the opposite party, but also more crucially, be able to ferret out information which can otherwise help you and which would not be available either in the pleadings or in the documentation. In a criminal law proceeding, this is even more crucial because in a criminal proceedings, particularly from the point of view of the accused, there is no real pleading in that sense. There are few statements made at prior occasions, but ultimately the entire case of at least the defense purely built upon the cross-examination. Therefore, in both of these proceedings, cross-examination plays an extremely crucial role, distinct from the other stages, whether it be of pleadings or of the oral submissions. Now, with that background in mind, I think we can proceed. If request for the first slide to be played. Yeah, Sushrit, could you please play the? Yeah, thank you so much. Now, as I mentioned, you will find if you a lot of these commentaries on cross-examination, or if you even take a look at, let's say, a lot of these online articles written by practitioners, you will frequently find this invocation of certain essential commandments or certain essential rules of cross-examination. Now, at the outset, I find these terms to be a misnomer because any rule or any commandment naturally means that under no circumstance can that rule or commandment be breached. And if it is so breached, then the consequences will obviously be negative. But in the case of a cross-examination, as I said, things are extremely contextual. A rule which may have been applied successfully in 99% of the cases may not be a rule which will serve your purpose in your case. And this is because of the mind-boggling variety of facts which may arise, and also because of the very human and inherently subjective outlook of witnesses. Now, for instance, P. Ramanatha Iyer, in his very, let's say, famous and popular treatise on cross-examination, if you look at the index, interestingly, he has a subdivision of the kind of witnesses who you will usually come across. Now, in my experience, some of these witnesses I have never seen in my life. For instance, he says, you will have witnesses who are honest. You will have witnesses who are straightforward. Mr. Iyer then identifies a certain category of witness as unintelligent witness. Now, there is another category called stupid witness, which I really don't know the difference between the aforesaid two categories. He says there are drunk witnesses. I've never come across them. And more fascinatingly, he says there is a category of witness called a hypnotized witness. Also a kind of witness I've never come across, but hopefully I will. So the only point I'm trying to make is that at best in a cross-examination, aside from your instinct, your past experience, and how well you've read the facts, there are no such real commandments or rules. And as observed in this judgment, the High Court of Nagpur, many decades back, ultimately the entire skill set of a cross-examiner depends on him or her being able to modulate the cross-examination and being able to think on their feet. Because ultimately a rule can only take you so far. Therefore, a rule or a commandment as such in a cross-examination, that is frankly speaking a misnomer. And ultimately, you must employ every discretion, every instinct available with you while cross-examining a witness, with the only caveat that you should also be aware of the likely consequences of deviating from a standard accepted practice. And if you are ready, if you are aware of what those consequences are, then you will be able to temper your discretion better. Now, with that thought in mind, if we can just move on to the next slide. Yeah. Now, what exactly is the aim of an effective cross-examination? Now, this seems pretty straightforward, but there is a slight confusion because of the popular understanding of what a cross-examination means. Now, in the next slide, we will obviously take a look at what not to do in a cross-examination. But essentially, when you do a cross-examination, it is never personal. You are not in any manner going after the witness who is espousing a particular cause or a particular version of events. You are going after what the witness represents in the overall background of the case of either the plaintiff, defendant, or the counterparty, to call it simply. Now, therefore, you must always have four basic aims or objectives. One, demolishing the credibility of the witness. Now, to demolish the credibility of a witness, it's not as simple as shouting at the witness, making it sound like the witness is immoral or someone who can't be trusted. Credibility here is an amalgamation of not only what the witness himself or herself represents in terms of truthfulness, but also in terms of how effectively he or she is able to reiterate the case which he or she has made out in the examination in chief. Therefore, your primary purpose in a cross-examination is, once the witness is off the stand after having been subjected to a cross-examination by you, the overall credibility of the witness, both at the level of being unable to articulate effectively their case, as also their general credibility as a person, has been depleted. So that is the first aim of an effective cross-examination, because ultimately, when you defeat the witness, when you defeat the credibility of the witness, you indirectly also demolish the case which is being espoused. So that is the next point. Therefore, even if the witness cries on stage, the witness starts bawling on stage, the witness rolls over, and you've demolished him or her. But despite that, if in the ultimate analysis of things, if been articulated in the examination in chief has still held ground, then you've not been able to really take care of the primary objective, which is to demolish the case being espoused, or at the very least, create a doubt. Because especially in the case of criminal proceedings, which are not, let's say, governed by preponderance of probabilities, if you are able to create even a reasonable level of doubt, then obviously you are a defense counsel, then it is going to be much easier for you to be able to secure an acquittal. The third aspect, and which most cross-examinations are not geared towards, is to elicit information is otherwise suppressed. Many a times when we see examinations in chief or depositions in chief, you will find that there will be a specific averment which is made in passing. Now, a witness may not really want to flesh out the entire fact in what is being stated in the sentence. For instance, a witness may say, I entered a particular factory premises at so-and-so time. Now, that is a very specific averment. But what you might possibly want to get from him is, or her is, why did he come at that particular point of time? Now, you may want to show why he was late. What are the circumstances that led to him being delayed? Did he enter into a scuffle before he entered the factory, etc., etc.? So a large part of cross-examination is not just demolishing, but it's also being able to elicit further information. And this is also ultimately going to help you with demolition, because as we come to it later, demolishing credibility to a large extent depends upon being able to attribute statements to witnesses, which you can subsequently move on to confront with, and therefore again weaken their credibility. Now, therefore, whenever we aim for cross-examination, all remember what Aristotle spoke about in terms of the modes of persuasion. So Aristotle said that if the best way to convince a person, though of course he meant it more in the context of oral advocacy, is that you must have the ethos, which is credibility, you must have pathos, which is emotion, and logos, which is logic. Now, as a cross-examiner, your ultimate aim is to break all three of these attributes in a witness. Therefore, the witness's credibility, his emotional appeal to the judge, we of course don't have a jury system, and the logic behind what is said in the decision in G. These are the three elements which you must aim to break. Now, with that in mind, if we can just move on to the next slide. What essentially are we aiming at once we do all four of these? As the Supreme Court noted in State of UP versus M. Anthony, merely getting a few deviations here and there from the witness, contradicting the witness on a couple of occasions, being able to demonstrate that there is a few slip-ups which the witness encounters either in the examination in chief or in the cross-examination, these are not really sufficient. Because ultimately, when a judge or an arbitrator looks at the entire cross-examination record at the end of the day, you have to be able to achieve something of the level of either the witness being completely discredited or there being extremely material discrepancies. Therefore, just because you manage to get in a few shots here and there, a hyper-technical view will rarely be followed, because judges also and arbitrators also are trained to understand that human memory is not infallible. So therefore, one must always keep in mind that when one cross-examines, one must never keep their eyes or take their eyes off the ultimate goal, which we will of course come to. But this is essentially a standard which we need to follow if you actually need to make cross-examination work at the stage of the oral arguments. Now, if we can just move on to the next slide. Right. Now, what are we not supposed to do in a cross-examination? Ultimately, many a times what happens is that, and it is natural, because you are now trying to essentially enter into some form of a chess game with the witness. It's natural. So as a human being, you are subjecting another human being to, let's say, a test of not only their mettle, but also their possibly powers of recollection, as also their general demeanor and credibility. Now, it is therefore very easy when one enters this contestation with a witness to make it personal. Now, the difficulty with this is you are essentially cross-examining, always remember this, cross-examining a witness who is factually probably better aware of what happened than you are. Because essentially, as a lawyer, you're going to be doing a post-mortem of a case by the time it comes to you. Therefore, if you try and just prove that you are smarter than witness, that doesn't really lead you anywhere. Because in many a times, you may get trapped in that, let's say, mutual exchange and completely lose sight of what the main goal is. As a connected point, you are not supposed to be playing to the gallery or to the client. Many a times you see lawyers getting extremely aggressive, roughing witnesses, humiliating witnesses, and that is not really something which really impacts the case in the long run. Neither does it really create any benefit for the party which is doing so. But because we all get, let's say, wound up in the emotion of cross-examination, it's very easy to be able to descend to that extent and have a one-on-one with the witness. Now, again, I say all of this is contextual. if a witness is being extremely elusive, or the witness has also already significantly perjured himself or herself and the credibility is completely gone, then naturally you can afford to be, very, very aggressive. But that aggression should never, ever, as I mentioned, be personal. It should always be directed at ensuring that the witness in question is able to demolish his or her own case and therefore support your own. And which is why it's very important to remember what Louis Misère said, that in cross-examination, just like fishing, when you see that tug on the fishing rod, you might think, that all I need to do is pull this fish in and therefore my work is done. But you must always be aware of the possibility that if the fish pulls back and it does so forcefully enough, then you're going to be in big trouble. Therefore, never focus on witness except for the point of view of seeing how it will affect the case as a whole. Now, if we can just go to the next slide. Right. Now, how do we prepare for this exam? Because as of now, we spoke primarily about theoretical aspects, how do we look at a cross-examination? But now, how do we prepare for one? Now, again, seeing it from a civil, in the context of a civil proceeding, the most important thing, firstly, is to get a bird's eye view of what the case is all about. So let's say you have a particular case and there is a witness therein who has to be cross-examined. The very thing you must ascertain is, what do the pleadings say? Because that is really the initial first cut of the case of either of the parties. Now, once you've gone through the pleadings, we need to go to the documents. This is a far more crucial stage. This is for the reason, many times in the documents which are part of the record, there will be issues, there will be aspects which would not have been brought up in the pleadings. Many a times you will find these minuscule, or let's say, not so important documents, which will actually contain significantly damaging material for the other side. Now, this obviously is a document that was required to be filed because it would look too obvious if it was not, or was within knowledge. But the text of that document might contain something which is extremely damaging. And therefore, the documents have to be gone in threadbare, not just the documents which the witness might take a look at in his deposition or his examination in chief, but also the documents as a whole. Now, in that backdrop, you must then come to the examination in chief. Now, when you come to the examination in chief, what you need to see, as I already mentioned, is what is the possible level of information that the witness is suppressing? How forthright has the witness been? And how do the witness's statements in the examination in chief deal with the pleadings? Because many a times you will see that once pleadings go through the exchange process, and you have a response to a plaint, or a written statement to a plaint, and a replication or rejoin thereto, parties slightly modulate their stance. Now, in many a times, the evidence of the witness will contain this modulation. Therefore, when a modulation occurs, it is something which you can categorize either as an improvement, or you can categorize it as the witness trying to speak something beyond what the pleading says. Therefore, be very sensitive in your examination in chief to what sought to be pleaded by the witness, which is in deviation to what is there in the pleadings. Documents, of course, you will probably use for a confrontation purpose, and that also you must be well aware of. Now, having seen this, and of course, in a criminal proceedings, you will obviously, if you are the defense counsel, take a look at the charge sheet. You might take a look at the statements made by the accused previously. You may take a look at the panchnama, etc., and then try and do under the same exercise. Now, when a witness essentially is attesting to a particular aspect, you need to be very clear of what are they attesting to. Are they a fact witness or an expert witness? Now, a fact witness is someone who is usually intimately connected with the transaction or the controversy in issue and deposes to something based out of personal knowledge. An expert witness is someone who has that expertise or knowledge or qualification in the field that the opinion which he or she gives to the judge or the tribunal is considered to be an expert opinion. Now, an expert witness is not really intimately connected with the facts of the case. He or she is somebody who is presented the facts in a particular manner by any party and then takes a call in terms of the expertise in the field and brings out a report in terms of what is the veracity of the case itself. So therefore, you have very clear. Now, how do we deal with expert witnesses differently from fact witnesses? I will come to at the end of the presentation. But for the moment, that is something we have to keep in mind. What is the witness attesting to? Now, again, even within a fact witness, you may have witnesses taking on very different onus. For instance, a particular witness may be dealing extensively with the factual narration behind let's say, a particular transaction. Now, there are certain witnesses who are only brought on to prove quantification. Now, for instance, you may have some in-house accounting person who is basically brought on record merely to show that as a result of a breach of a contract, this is the amount of damages which were suffered by a particular entity. Now, in such a case, the onus is significantly lower, and the onus is also significantly fenced, because that particular person is only considering a very limited aspect of the controversy. Therefore, you need to tune your cross-examination accordingly. We'll see how we do that when we come to the slide subsequently. Also, we need to take an understanding of what is the identity and role of the witness. This is important, because many a times you will see that there are persons who are brought on as witnesses who are significantly lower down in the rung of that particular company or that entity. Now, this sometimes happens in cases where the people who are the top honchos, like the MD or the manager, who might otherwise be well versed with the facts of the case, are reluctant to enter the witness box. So it happens quite often that witnesses who are very lower down in the let's say, the hierarchy of the particular entity, or even, let's say, the employee of a sole proprietorship, they are put on the witness box. Now, people who are very lower down in the rung are in many ways more convenient to cross-examine, because they have a lot riding on the cross-examination, because the pressure is significant. And secondly, they are much easier to be confronted with previous documents, which usually are exchanged at a much higher level. So when you confront a witness who is very low in the pecking order with, say, or something written by a managing director or somebody, the witness usually does not have the wherewithal to be able to give a satisfactory answer. So that is very important. What is the identity of the witness within the transaction as a whole, and also within the company or within the hierarchy of the opposite party, the counterparty? And also, what is the role the witness plays? For instance, in a construction contract, you will have a design expert on the field. You will have a quantity surveyor on the field. Now, for an issue with regard to a problematic design, if you have a quantity surveyor coming and attesting to that fact, then naturally that role is extremely mismatched. And therefore, you can do a far more effective job than you might have been able to if the concerned person had come over. So therefore, always be aware about the identity of the witness and the role that the witness plays in the context of the case. Now, what is the overall burden that the witness is carrying? Why is this important? This is important because, and this is far more crucial for civil proceedings. If we can have the next slide, please. This has become quite rampant now, this practice of essentially copy pasting entire pleading, whether it be the suit, the plaint, or the written statement, or in case of an arbitration, an SOC or an SOD, and then putting it in the form of an affidavit and sending a witness across to prove the same. This is not how things are supposed to be done. I know I'm slightly digressing from the concept of cross-examination, but this is important to understand, because a large variety of cases today, if you see the witnesses, the kind of onus the witness takes on is mind-boggling. Because usually, as this judgment of Justice Pratibha Singh very clearly enumerates, a witness is only supposed to be put in place to depose on what is specific to that witness's area of expertise or to his knowledge base, or to the personal knowledge which he may have encountered. But now increasingly you are seeing in proceedings, one witness who may have done, say, a limited role in the transaction, coming and trying to plead the entirety of the case as reflected in the pleadings. Now, not only is this bad in terms of practice, but as a cross-examiner, this gives you brilliant opportunities. Because in my experience, a witness who takes on a large onus is always far more susceptible to mistakes than a witness who's pointed and whose onus is very limited in terms of proving a particular fact or proving a particular set of facts. Therefore, this is something which happens extremely often nowadays, and it is not something which is good practice. But as a cross-examiner, if you get a witness like this, then it is something, which is usually a positive sign. Now, if you can just move on to the next slide. Right. Now, also when we prepare for a cross-examination, how do we go about doing it once we've done the entire overview of the documents, the pleadings, etc.? See, the most important thing to do is now, especially in this era where in the under the CPC, you are permitted to now file an examination in chief through means of an affidavit. Earlier, before 2002, just like in criminal proceedings, the deposition in chief primarily used to be taken not through an affidavit, but by a direct examination of the witness concerned by the counsel. This continues to be the case in criminal proceedings, but in the case of civil proceedings, now after the amendment to the CPC, you are permitted to put on record an affidavit in lieu of examination in chief. Now, what this means is usually, as we already saw in the judgment of Justice Pratibha Singh, it leads to a garrulous reproduction of the entire pleading itself. Now, when this happens, it is an important task to basically see what is being said in that particular affidavit, which is really crucial in terms of the issues in contestation. Because in a pleading, you will have a variety of averments, which may either be undisputed or may not really having a huge bearing on the case. Therefore, whenever you have a witness deposition, which is rambling, which is garrulous, you need to be very, very clear to determine the issues which you need to cross-examine the witness on. In the same light, you need to have very clear-cut objectives. Because in a cross-examination, it is a very wrong practice to pick up each and every sentence and cross-examine the witness on it. That is, frankly speaking, an unnecessary exercise. Also leads to an unduly long cross-examination and therefore reduces your credibility. In the same light, always aim for the bare minimum. See, all of us would want, obviously, every cross-examination being able to demolish the witness, for the witness to come off the stage or of the stand and for you to think that, oh, wow, this case is over. But that doesn't usually happen. Now, therefore, you need to be clear in your mind, what is the bare minimum you need to get out of a witness on a particular issue for you to succeed on this subsequently. If you do not establish this basic parameter, then you're going to be tempted to keep on cross-examining. And that can come with its own dangers, including the witness being able to fill up any lacuna which he may have had introduced on account of earlier questions. Now, again, people follow very different methodologies. You will see counsels who will come with sheafs of paper containing each and every question which they want to ask. That is one possible strategy I have seen being utilized by certain counsels. Others only jot down the main bullet points and then try and articulate questions on the spot. I have personally felt that a combination of both of these is good. Issues which are extremely critical or a few questions which you know for sure, irrespective of the witness's responses you have to put in, you can possibly make a mix of. But I would still suggest not to be completely bound down by written questions, because then naturally there is a tendency for you to keep looking at the sheaf of paper. And after that, to basically, to a certain extent, it will gridlock your free thinking and your ability to be able to think on your feet. But that's my personal experience. Like I said, I've seen both strategies being followed and successfully at that. Now, also, whenever you're cross-examining a witness from the point of view of contradiction, you must also have in a binder or a convenience compilation the relevant extracts from the pleadings and the relevant documents, which you would want possibly to confront the witness with so as to impugn his or her credibility. This is also something which is purely a matter of personal preference. I've seen people flag, even voluminous volumes and then essentially take out the document. But personally, it is always preferable if you have a convenience compilation. Yeah. Request for the next slide, please. Right. Now, the basic mantra whenever you're doing a cross-examination is control, credit, and contradict. So as a cross-examiner, and we will see how the questions are tuned to this, you must always control the dialogue. The minute the witness is able to volunteer answers significantly or is able to give you detailed explanations of what he or she is saying, you lose control over the entire process, and which is destructive for your effectiveness. After you maintain control and get the questions you need to credit the witness. Therefore, either when you look to confront the witness, either with, say, a document or with a prior pleading, you must be able to bring on record previous statements or stands, which you can credit to the witness or to the party which he or she is representing. Therefore, you must be able to identify contrary statements. You must be able to identify within the cross-examination themes which don't gel well, or areas where the witness might be seen to be very vacuous about an event which he or she was very specific about earlier. Therefore, you must be able to credit to the witness prior statements or prior stands, which you can then use as a base to be able to contradict, which is the third point. So the entire aim of a cross-examination, aside from possibly getting more information out, is to contradict the witness. So if you control, if you credit, and you contradict, then to a large extent, the successful mantra for a cross-examination has been taken care of. Now, if you may just have the next slide. Right. Now, well, I think this is also a good example of why one should not possibly not have questions, because just like when you have slides, you're so comfortable just looking at the slides and doing the seminar accordingly. But I thought this would be more useful from a future reference point of view, which is why I incorporated the same. Now, what is permissible in a cross-examination? Now, this is important because a lot of the times, we hear these terms which by their very nature sound, let's say, problematic. For instance, all of us, generally, let's say, identify leading questions as being something negative. Because we've all heard, oh, that's a leading question. It's not permissible. But that's the beauty of cross-examination. As compared to an examination in chief, in a cross-examination, you have significant leeway to ask questions. You are essentially the master of the stage. Lead questions are expressly permitted. Now, leading questions are those which have the answer implicit in them. For instance, if you ask somebody, is it not correct that you were wearing a red shirt on so-and-so day when you attended the office? Now, that's a leading question, because you are telling the witness exactly the answer which you want to get from him or her. Or if I may put it in some other formulation, these are questions which usually only have a yes or no answer and are not open-ended in the answer which they get from the witness. Now, also what is important to know is in a cross-examination, you are not necessarily bound only by the facts which a witness attests to. Because in a cross-examination, if you are even able to introduce a question which pertains to a fact which may demolish the credibility of a witness, then those questions will be permissible in cross-examination. Now, because these issues of irrelevance, etc., have been interpreted generally widely by the courts, therefore, you have a significant leeway in being able to ask these questions. But of course, there are certain limitations. You can't ask a witness completely reckless, scandalous, or manifestly irrelevant questions. For instance, in a case involving quantification of a particular element of damage, you might be able to ask a witness if the witness is a habitual drunkard, because that may to a certain extent have certain relevance to the ability to quantify. But now if you ask a witness if he's married and if he's having an affair, that's frankly speaking a question, because in his ability to be able to depose truthfully about, say, a quantification, that not strictly be relevant. But again, like I said, this is also very contextual. Sometimes if in a matter involving a case of fraud, if you have a witness testifying, let's say, to the character of a particular person, then that witness obviously will be expected to have, a character which is good of his or her own. So in such subjective circumstances, you might be able to get away with a question which might seem scandalous, but the general rule is you can't have reckless, scandalous, or abusive questions and completely irrelevant. For instance, a witness who is a fact witness, and you can't ask him a question about the law. You can't say, are you aware that this action is a breach of sections of the Indian Contract Act? He or she won't be able to answer that. So that's completely irrelevant. But again, if he's an expert witness on law, then possibly you might be able to do that. So all I want to get across is in a cross-examination, you have a huge leeway in terms of what you can possibly ask from a witness. Right. Now, if we can just move on to the next slide. Right. Now, when we go to basic cross-examination strategies, again, I would like to place that caveat on record that these are all essentially best practices. They will, maybe some of these may apply to 99% of situations, but there will be that 1% case where none of these might apply. So therefore, that is something which you have to go by instinct, and that's not something which I would prefer to gridlock ever. Now, always remember, it is always, as we already said, once we identify these themes in a cross-examination, what are the main points in issue, what do you need to ask the witness, it's better to go into a cross-examination within these themes, because then you have better control, you know exactly what you want to ask the witness, and also you can shuffle between these themes to take the witness off guard. Because go through a cross-examination chronologically, in the sense of how the witness usually will place the deposition or the examination in chief, then you make the witness a bit more comfortable. And it also makes it harder for you to be able to really get at the distinct themes which are are going to help you build your case in the future. Now, as we spoke about control, you must always try, and this is why people say leading questions are preferred. You must try and ensure that the information always comes from you, not the witness. So is it not correct? Am I correct in saying? Would you not agree? So all of these are precursors to a statement which you want to put to the witness. And if the witness only answers in yes or no, not only do you exercise control, but you also improve your credibility. Because when you look at the cross, everything you're saying the witness is agreeing with, even though he or she is on the opposite side. This is why leading questions are the norm. Because in a leading question, you are usually able to restrict the witness to a yes or no answer. So therefore, in most of these commandments or principles of examination, you will have a rule saying only ask leading questions. But I may differ slightly from that for two reasons. One, even in leading question, it is up to the judge or the arbitrator ensure that the witness is able to volunteer an explanation. That's something you can't stop in all instances. Some questions you might be able to say nothing doing, I don't want an explanation, but it's always a discretion of the judge or the arbitrator to permit a witness to volunteer. And that is something which a lot of these rules don't take into account, especially I think in the Indian context, that when you have a witness volunteering, then a large part of what is permissible is determined by the judge or the arbitrator. Therefore, merely because you've asked a question which is, let's say, not open-ended or a leading question, you can't ensure that the witness is only going to be able to give you a yes answer. Also, what a lot of people don't take into account is the possibility of re-examination. Let's say you asked a witness 100 questions and each of them you've been able to restrict the witness to a yes or no answer. Despite the other side then has the opportunity to re-examine the witness. And in that re-examination, they might be able to flesh out an explanation which would then, not really serve your purpose. Therefore, in certain cases, open-ended questions, are better if the trade-off is not significant. For instance, there are certain issues on which you know for a fact that a witness, even if he gives an open-ended question, will not really be able to demolish the main plank of your case. Now, let's say this witness is very elusive. For instance, you have a quantity surveyor. You ask him everything under the sun. And for everything which are related to the facts of that particular case, him being a fact witness, he says, I am not aware, I do not remember. Now, therefore, in such a situation, to have him open up, him or her open up, it is good to ask an open-ended question. For instance, when you went on the site, what did you observe? Now, this, of course, comes with a certain risk. But one advantage of this is he or she is then forced to open up. You can't tell an arbitration tribunal or a judge when you are asked that what were you generally doing there, why I'm not aware. You can't do that. You may get away with it for a specific question. So once that witness volunteers that information, you might be able to pick crumbs of that and then corner the witness into a future question where he simply can't say I am not aware because he's already attested or deposed in response to your earlier general question. So in some cases, you may need for the particular witness to be asked an open-ended question because you may be in deadlock or, you are just not going anywhere with it. But again, like I said, this is a risk-benefit analysis which you have to take on the basis of your mastery of the facts and your general experience and instinct. Right, if we can just continue. Right. Now, again, one general rule which we always follow is ask straightforward and simple questions not containing multiple variables. Now, why do we say so? One major reason for doing so is ultimately you have to always take into account a time lag between testimony and its appreciation. See, in the Western context, many a times when you have a civil proceeding or a criminal proceeding, the judge who listens to the cross-examination, or the jury who listens to the cross-examination are ultimately the people who are adjudicating the case. But in our context with the pendency of cases, except in the case of an arbitral tribunal, in the case of civil courts or criminal courts, many a time the judge who is finally hearing the arguments many years later after the cross has ended will never have the benefit of demeanor or the exact context of what a witness responded to, because we will only have the text responses. In such a case, if you have let's say a question with multiple variables, for instance, if you say, did you not wear a red colored shirt and put on this perfume and these shoes on that day? Essentially, you have three variables. Now, if the witness does not respond simply in yes or no, then essentially if he gives a more complex answer, you may be stuck at the stage of final argument to demonstrate what is the variable to which the witness responded in what manner. And more importantly, this becomes a problem for you in terms of attributability. Because when the witness is given a very complex sort of question, then a answer which comes might in future be construed as having been given because the witness was too confused about the question. So that is ultimately your aim. That is exactly what you're aiming for. But if your question makes that too obvious, then in future, the benefit which you would have derived from that, let's say, very bad answer from the witness, as far as the other side's case is concerned, you may not be able to reap. But again, like I said, this also is something which is not, something which can't be deviated from. For instance, you will have witnesses who have excellent common sense. They may not be the most articulate, but their common sense will be brilliant. So then if you put a witness who is extremely commonsensical, a very straightforward question, then usually they will do a very good job of dealing with it. So in some cases I have seen, where witnesses are essentially being able to respond very effectively to questions which contain single variables. It's always better to put in place a more complex question, because that helps break the witness's chain of thought. And a lot of witnesses who are excellent in terms of being commonsensical are not so good when it comes to articulating or expounding on certain more complex issues. Therefore, if you complicate a matter, if you introduce multiple variables, an otherwise confident witness may not be able to carry on so effectively in the future. But again, like I said, this comes with the relative demerits of the lack of engagement and attributability. Therefore, it's not something you do all the time. It's more of a strategy in the middle. Can I request for the next slide, please? Right. Now, another basic thumb rule is always know the answer to the questions you ask. Well, this is obviously very commonsensical, because when in a cross-examination, you must always be aware of the potential direction that the answer may take. Now, if you ask something which even you are unaware of, then you are basically entering into a completely, dark room. And you have no idea, once the witness answers the question and the light is turned on, what you will find therein. But sometimes you need to take a leap of faith, because there may be aspects when you are not really aware of, certain issues, or you are not aware of the stand of a particular person, because neither the pleadings nor the documents nor the examination in chief really reflects that. So in such a case, if you think that there is definitely a benefit from being able to get that response from the witness, then you can gradually work your way up to that question. Example I will tell you. For instance, there was a case where there was an arbitration going on between a subcontractor and a contractor. Now, when this arbitration was going on, I was appearing for the subcontractor, and the contractor had made a counterclaim for LD on us, liquidated. Now, ultimately, what could have demolished the case for LD was if I was able to demonstrate that there was no LD imposed by the principal employer on the contractor in what was essentially a back-to-back agreement. Now, but the trouble with asking that question was my clients were really unaware. Now, if you ask that question, which was nowhere reflected in any of their pleadings or documents, the answer to that question, and the answer said, yes, LD was imposed, then you are in serious trouble. You're supplying, a case to the other side, which they didn't bother to make. So then you go to the roundup questions. You say, did the main employer raise any quarrels with you about the work you did? Was the main employer satisfied? You ask those roundabout questions. And when you're sure, when your instinct tells you that the witness has now gone too far down the path to be able to now recant, then you can shoot off that question. But in the middle, if you get bad feelings about it, so if the witness says, yes, the employer did complain to us, etc., then you can retreat and not possibly put in place that question. Again, like I said, it's very contextual. Now, one thing also is important from a human perspective is that always try and employ the words which the witness uses. Because as lawyers, we have a tendency to use far more technical terms. Now, when you use technical terms, one difficulty is the witness is absolutely on the defensive. Because the witness thinks, oh, technical term, the lawyer is using it. So obviously, he is trying to do this to trap me. Or there is a hidden meaning behind these words. That makes a witness feel paranoid. Now, paranoia might be right, good thing in terms of the pressure it exerts on the witness. But one problem with paranoia is that it then makes it far more difficult for you to be able to get out information. Because if the witness does not want to volunteer anything at all, because he or she believes it will be something which will be used against the party or him or her. Then, if you use the words which were used by the witness in the deposition in chief, if you reproduce the words which were used by the witness in the prior portion of the cross examination, makes for a far more conversational style and helps to put the witness at ease as far as responding to you is concerned. Now, one golden rule, which definitely I think, irrespective of context, is one must know when to stop. Now, the one problem with not doing this is that many a time you may have gotten an answer which was excellent, or you may have got an answer which created doubt, both of which are good enough. But that temptation, that tendency to ask that one question more, because you think you have the witness on the mat, might create a situation where the witness realizes where he is going wrong and tries to circumvent or clarify what was the obvious admission, which he or she made in the previous part of the cross-examination. Therefore, that is very, very crucial, knowing when to stop, again, knowing what is the bare minimum. Now, what happens in a case where the witness is completely elusive, stubborn, refuses to answer? In that case, you can temporarily put a stop to the cross-examination on that particular theme, move on to another theme, and then come back to the same subsequently of a more wavered procedure. This ensures that the witness is no longer on guard, and that stubbornness which he or she exhibited might loosen up with the passage of time, and the alertness also will be loosen up with the passage of time. Now, if I may only have the next slide. Right. Now, this is something which is very common. What do you do when a witness is elusive? This happens regularly because you will have witnesses saying, I am not aware, I do not remember. Now, if the witness does this too often, then obviously the credibility goes for loss. So that's not necessarily a bad thing. But sometimes on some critical themes, a witness may hardball. In such a scenario, what you need to do is soften up the witness by asking questions which are otherwise purely within his or her area of expertise, or within areas of personal knowledge which he or she could not under any circumstance detract from or claim that they are unaware of. Once you start putting in those softballs, once the witness starts answering confidently, there is generally this tendency that once we are on a good streak, we want to continue that. So therefore, after say 6 or 7 very good questions, make us feel more confident, but ultimately don't impact your case so much. If you are then able to put in a question in a slightly differently worded way, asking the witness about this very fact about which he or she was stubborn earlier, then there is a possibility that that momentum carries forward and the witness volunteers something he or she may not have done earlier. But again, you have to be very careful here that you can't repeat a question. Or you have to word it in a totally different manner so that there is no objection on that front. Again, very important, despite the temptation, never make an underdog out of your witness. See, because ultimately what a lot of people forget is that there are 3 actors in this entire scenario. There is you, there is the witness, but there is also the judge or the arbitrator. Now, under the Evidence Act and general rules of procedure also, especially when we have contested proceedings, the judge or the arbitrator has a significant leeway in being able to intervene during the course of the cross-examination. Even though you are entitled to have a long rope, if somebody feels that a witness is being browbeaten or he's being unnecessarily roughed up, then that natural tendency of sympathy emanates towards a witness. This is something which you want to avoid. So even though you can adopt aggressive means of cross-examination, you can be very direct, you can point it, never let it come to a situation where, you make an underdog out of your witness or, generate unneeded sympathy for the said person. Now, having said that, there are a lot of cases where judges or arbitrators might seek to, let's say, I'm not really getting the correct word, persuade you to, end the cross-examination early. Now, obviously, a short, crisp cross-examination is a virtue in itself, but never ever allow a persuasion of that kind to, let's say, completely not ask questions which are relevant to yours. Because ultimately now, especially with the time pressure on courts, there is a lot of situations where a court or an arbitrator will pressurize you to conclude a cross-examination. But if there is still elements of the deposition or the examination in chief which are critical and which you are yet to engage with, you must be firm and in a polite manner. You can tell the arbitrator or the judge that not being able to get this opportunity would significantly prejudice your case. that therefore you must be given the same. And you can possibly, give some sort of a leeway. You can say, okay, I only take this much more time. Do get those questions in, because at the end of the oral arguments, no judge or arbitrator is going to remember or let you make an argument that, sir, I wanted to cross-examine, but you didn't let me. That obviously is not a answer you can give at the stage of oral arguments. If you are asked why you didn't touch upon something, can be a slide, please. Right. Now, when also remember that many a times when you get a sudden response from a witness, despite being well prepared for it, there are circumstances where you may not be able to immediately, let's say, engage with that line of thought. So you always need certain filler questions. These are questions where, you are working within your brain to think of something, where you can continue with the cross-examination in an effective manner while not making any mistakes. So to get you filler time, it is always good to have a few, let's say very, very easy or completely inconsequential questions, though relevant to the facts, which you keep on the side as filler questions. Because in the odd chance you caught on the back foot, you need time, then you can put in these filler questions so that, that mechanical exercise continues and you are able to then contemplate the way forward. Again, this, in terms of witness, don't get personal aspects of character, etc., unless the case itself calls for it. And many times things do get heated with the witnesses. Now, when they do get heated, never try to beat directly, because one aspect of that is that then it becomes a personal sort of a slinging match. So if you then at that stage call upon the judge or the arbitrator to rein in the witness, you have two advantages. One, the witness is reminded of the fact that it is a solemn proceeding and he or she is under an obligation to answer. Secondly, the judge or the arbitrator also gets a satisfaction that you do respect the prime of that particular individual in terms of conducting the proceedings. So therefore, if you do it on your own, you have those problems of, maybe getting misplaced sympathy for the witness, the arbitrator or judge thinking you too rough, etc. Now, in cases, where the intent is not to contradict immediately, see, because there are lots of contradictions which you might not want to bring up then and there and contradict a witness. You may want to keep an answer to yourself. Then at the stage of final arguments, you might want to use that answer to contradict the case as a whole. Now, therefore, you have to then also make a distinction between some answers which you don't want to use immediately to contradict. Now, in these sort of answers, if you want to expound even more, try and ensure that the questions which are coming from you are not questions where purport of that particular question is very, very clear. For instance, if you ask someone a direct question, then it should not amount to a question whereby what you are hinting at is very, because nowadays when a cross-examinations, what happens is cross-examinations may be staggered over many days. So at the end of the day, when the opposite side lawyer or the witness reviews that script of the cross-examination, if what you are getting at is very, very clear, then the witness may be tutored to respond to that particular point in a subsequent day's cross-examination. Now, again, this is not easy, but once you have a clear idea of what the cases and the facts are, then it is possible many a times to implant these hidden bombs, which the witness responds seemingly innocuously, but at the final argument stage, it becomes a millstone around his or her neck. So in the same light, don't permit vague answers. When you ask a witness something and they say, maybe so, I can't really remember, etc., don't let them get away with that answer. Because once you do that for 2 or 3 or 4 answers, then the witness becomes comfortable with the understanding that he may be or she may be able to get away with doing this. Therefore, even though, of course, you can ask the arbitrator or the judge to intervene once things get out of hand, it is usually better not to permit this at the very outset, because then, you don't really run the risk of this becoming more of a practice. So this is basically, what to do in terms of the witness's answers. Now, if I may have the next slide, please. Right. Now, again, we already discussed, if any portion of the examination in chief is favorable, don't run the risk of ruining it by a cross-examination. Because like I said, many a times in a examination in chief, there may be aspects which may have been pleaded completely contradicting the party's own document, right? A very crucial document at that. Now, this is not something which you want to be clarified in a cross-examination, because then the effectiveness of using it in the final arguments goes away. Therefore, always identify portions which you should not examine on and leave only for the final arguments. Now, again, you may have to play indoors of the very same cross-examination, a good cop, bad cop approach. Elements where you want to quote information, adopt a more genial approach, a more conversational approach. Where you want to contradict, where you impugn credibility, switch to a far more aggressive mode. So you must know when to switch between these. Now, again, don't ever ask a question, the answer to which is clear in the examination chief. Why is this so? See, the credibility given to answers in an examination, cross-examination, is on a higher pedestal than an examination in chief. Why is that so? Because law, in fact, goes to the extent of saying that if an affidavit in evidence in lieu of examination in chief under the CP, for instance, if that is not subjected to cross-examination, then that deposition is inadmissible. So therefore, the test of what is said in an examination in chief is how well the witness is able to protect that in the cross-examination. Now, therefore, anything reiterated in the cross-examination is on a higher pedestal in terms of, probative value. Therefore, don't allow the witness to repeat things that are there in his examination in chief. And the first step to doing that is to ensuring that you don't have questions which are to that effect. I think the PowerPoint is lost. I don't see the slide. Can I just have the next slide, please? Right. So as far as a slide comes back, I'll just move on to the subsequent points. Now, if you have any aspect, or if you have absolutely any doubt about the fact that something fundamental is left to be dealt with, then please, by all means, continue with the cross-examination. But do not overstretch it. Now, the reason why I say so is that it is always a good, possibly, strategy to cross-examine a witness over a long period of time. With the length of time, etc., the chance of the witness making a mistake is that much higher. But this must be weighed against many judgments of the courts where they have held that when there is a protracted cross-examination, then the court will be a little bit more lenient with inconsistencies in the testimony of the witness, because naturally with that long duration of time, it is natural that there would be some inconsistency with what the witness says. So therefore, if you have a witness who has a massive onus, by all means, undertake an extensive cross-examination. But usually the purpose of a cross-examination, like I said, is not to exhaust. It's to get what you want out of the cross-examination in terms of the merit of the matter. And that is what you should be focusing on. So these are basically, some overall strategies which one may employ. Now, as I said in the beginning, I had spoken about the difference between a fact witness and an expert witness. Now, whatever we've said so far applies across to a fact witness as also an expert witness. But in the case of an expert witness, there is something, there are some elements which we need to take a look at in addition to what we've already spoken on. Now, what is an example of an expert witness? Now, for instance, I spoke about how a fact witness, a company may produce its own, let's say, account officer. A company may produce its surveyor. A company may produce an employee of its which does design work for it. All fact witnesses, though they may have some elements of expertise also. But let's say it picks up a third-party entity. For instance, if there is a particular issue about who is responsible for delay in an infrastructure proceeding, an arbitration. Now, your party says it's the counterparty which is responsible. They say something to the contrary. Now, it's very common in infrastructure contracts to have a delay analysis expert come and give testimony. Now, this gentleman will usually be somebody with an engineering background who have extensive experience in delay arising out of infrastructure contracts, might be peer-reviewed, might have published significantly, might be considered an expert in general. So let's say a delay analysis expert is brought on board by the counterparty, and you have to cross-examine this expert witness. So what are the additional elements you have to keep in mind? One, personal credibility. See, the importance of personal credibility for an expert witness is that the court is going to consider this person as detached from the case as such. Because an expert witness, technically speaking, is not somebody who is supposed to have some personal interest in ensuring that the party on whose behalf it is deposing essentially succeeds in the matter. The reality might be different, but that's not how experts are seen. Now, therefore, if an expert, for instance, an engineer who is a delay analysis expert comes, you can attack personal credibility in some ways. For instance, you can ask him if he's the professional organization of which he is a member of. Let's say there is a professional organization of delay analysis experts. That organization, for instance, in the case of lawyers, you may have a bar council or a bar association. You may put the witness questions like, have you ever been disbarred by a professional association of delay analysis experts? Have you ever been convicted of a crime involving moral turpitude or, for instance, misappropriation of money or something of that sort? So therefore, in such a situation, you can impugn witness's credibility by asking him or her about her personal qualifications or personal credibility. Then independence. Now, independence is important because even under the Evidence Act, the aspect of impartiality of a witness is important. Now, an expert witness, there is a presumption is independent. But how do you say that is not the case? You can bring up past associations with this very. For instance, you may ask this witness, how many prior cases have you deposed in favor of this party? Now, if the witness says 6, 7, then naturally, you may come to a conclusion that this witness is somebody, who has, let's say, a very close personal involvement with the party. Therefore, demolishing his credibility in terms of the impartiality. I think we need to come back to the expert witness slide. Request for the expert witness slide to be put on. I think we've gone back to the general view. Right. Now, aside from independence, you can also obviously impugn qualification. Now, when an expert witness comes on the stage, you ask him or her as to how many publications they have had, how much practical experience do, because somebody may have a lot of degrees and somebody may have published extensively, but let's say they've never been on a work site. They've never really seen how construction work happens. So obviously the probative value of their evidence goes down to that extent. You may have a case where you have let's say a particular witness who's never really been peer reviewed. A lot of the experts, they are able to essentially place, let's say, a lot of publication. They in prestigious journals, they are called upon to give talks, etc. So if you're able to ask a witness this and turns out this gentleman or this lady has never really done anything of this sort, that again impugns upon the credibility. Now, as soon as the slides are back, we will go back to that. But then also you can impugn somebody by talking about consistency. See, one advantage with having an expert witness is that you will generally, because they are supposed to be people who are out there in the field, you may many a times find prior opinions available in the form of academic writing, in the form of speeches, in the form of videos, etc. So therefore, if you're able to put to a witness, some inconsistency between what he or she opined on the same matter a few months back or a few years back, then you can really demolish the consistency of the witness. Another important thing which you need to focus on are the inputs provided. See, usually what happens with expert witnesses is when I want an expert opinion from a witness, the party in question will usually curate the information which is being provided to the expert witness. So you will make a dossier, these are these 100 documents, please see these documents and please tell me why this delay is not on my part. Now, many expert witnesses in their, let's say in this term of their arrangement with the particular party to depose on their behalf, because most witnesses have a professional agreement with the party. And there's something I forgot when it comes to independence, you can ask for a reproduction of that particular agreement, because in some agreement, the witness may have given a guarantee that he will provide a positive opinion. Now, if that agreement is there, then again, the credibility and the impartiality goes completely out of the window. So that's something you can also do to impugn the witness impartiality. Now, coming back to the inputs provided. Therefore, if you ask a witness, what did you review? Did you only review the documentation or the pleadings which were supplied to you by the party? Or did you independently undertake a review or a requisitioning of additional material for you to arrive at a conclusion? Now, in many cases, you will see, in many cases, experts will only have looked at certain material which was provided to them. And if you are able to demonstrate that input was too narrow, or that it missed out on critical documents which would have proved otherwise, then again, you can demolish the expert witness. One other important aspect is the methodology adopted. See, for most expert witnesses, when they're opining on something technical, say for example, delay, say for example, the amount of compensation payable on account of a specialized industry, they will follow certain industry standard methodologies, certain theorems. For instance, in construction law, you have a lot of these, formulas we used. And even the Supreme Court, in fact, has actually given its imprimatur to such, a methodology. So you may have the Hudson's formula, etc., etc. Each industry or field will have their own formulas. Now, therefore, if you are able to show that the methodology adopted by the witness is not industry standard, or that methodology has been heavily criticized, or that even in a generally adopted methodology, people have talked about errors for which you need to put in place a margin, has the expert taken into account that margin? Therefore, the methodology which is used by the witness also is something which can be attacked by you. Finally, a witness usually, in terms of the deposition, will provide a report, an expert report. Now, in the expert report, of course, you can quibble with a lot of aspects. You can quibble with like errors, typographical. You can deal with, the overall theme of the report, how it doesn't gel. The reasoning may be very poor compared to the ultimate conclusion, etc., etc. There may be mutual inconsistencies. So even within the text of the report, must just like what you would do in an examination in chief of a fact witness, you are always entitled to point out these errors or omissions or contradictions. Now, in a fact witness, let's say a witness misspells a word, a witness gets a technical term wrong or writes a technical term and is not able to answer what that is, there will be a lot of leeway. But if somebody comes and says, look, I am an expert in this field, I know everything there is to be known about this particular field. If that person, makes a mistake on a technical term or uses, let's say, poor language, etc., then it is seen, with a far more harsher eye than a fact witness who is primarily only concerned with the facts as opposed to this overall theory. Now, only move to the next slide. So this is basically, the entire aspect of how to cross-examine expert witness in addition to what we've already seen for the fact witnesses. Now, one thing which I wanted to address, which is a little important, is the role of suggestions. Now, what is a suggestion? A suggestion is a form of a question in a cross-examination where you put your case to the witness. So, for instance, you will tell a witness, if you say delay is not on your part, then you will say, is it not correct that, the delay is on your part? Now, that is something very fundamental because your entire case is that the delay is on their part. You need not really put that to a witness in the strict sense, of a suggestion. But suggestions have now become rampant in cross-examination. Just like we saw how in a examination in chief, Justice Pratibha Singh's judgment, where she mentioned about how copy-pasting en masse pleadings is not a correct way. Similarly, in a lot of cross-examinations, you will see the majority of the questions are suggestions. Now, I may make again a caveat here. In a criminal proceeding, suggestions are very important because in a criminal proceeding, particularly if you are for the defense, you don't really have any pleadings. So aside from a few statements you may have made before, again, the admissibility of which is again a matter of doubt, you don't really have any statement of case. So if you are for the defense in a criminal proceeding, suggestions are extremely crucial because everything that you suggest is made part of your case, and only those suggestions will then permit you to answer something, to argue something at the final stage. For instance, there is a particular case you want to make out, but that case was never to a witness. Then a trial judge in a criminal proceeding at the last stage may say, you never gave the witness or the prosecution a chance to rebut this or deal with this. Therefore, you can't introduce this for the very first time in the final arguments. Now, in a criminal proceeding, suggestions are extremely important. But in a civil proceeding, they may not be all that important. And also kindly consider in the background that a suggestion by itself does not really prove your case. Just because you tell a party that, look, I put it to you, delay is yours. Naturally, the witness is going to say, I disagree. So that exchange by its own does not in any manner help you in proving your case. Now, therefore, in this slide, let's go to the next slide. There is also a judgment of the High Court of Delhi where Justice Rajiv Sahai and law has opined on how, this entire practice of suggestions in criminal pleadings has seeped its way into civil proceedings, and which should not be the case because the purport of these two proceedings and the significant suggestions are very, very different. Now, again, I was speaking to Aditya Swarup about this, and then he was telling me about how in Bombay and in Calcutta, they may hold a slightly different view because there are judgments which emphasize upon the importance of suggestions in a cross-examination also. Now, I will only say this, that ultimately, whether in the form of a question or a suggestion, you need to engage with what is the fundamental defense of the other side or the fundamental point of the other side. You can't leave it completely untrammeled. But one way of going about the suggestion business is the difficulty is once you ask 5 or 6 suggestions, then in a way you are implicitly conceding to the fact that suggestions are important. Now, in a 200-page examination in chief, if you are stricto sensu asked to give suggestions, then it is a mind-boggling exercise and the cross will never see the end of day. So therefore, I think the appropriate balance is possibly trying to get that clarification at the beginning of the cross-examination, that you will not be resorting to an overall suggestion, and that you will possibly be giving that suggestion at the end, which we all do in civil proceedings, that one last suggestion to a witness where you say, I put it to you that you are deposing falsely. Now, like I said, there is no determinative view of the Supreme Court on this. Therefore, different jurisdictions may have different approaches, but at least, emanating from Delhi, this seems to be the view. Now, if you can just have the next slide also. Right. Now, see, as I already mentioned, I am uncomfortable with the term rules or commandments in a cross-examination. But one very, I would say, let's say simple and easy to remember set of instructions are Irving Younger's 10 commandments of cross-examination. Now, as we already saw, most of these we have already covered. Be brief, ask short questions, words, always ask leading questions. Now, like I said, this essentially does communicate the fundamental essence of how the majority of the cross-examinations should be conducted. But again, like I said, there is always a danger of following a completely gridlock system of rules, because in the context of your own case or in the context of the peculiar witness, none of these rules might be effective for you. So therefore, again, like I said, this is something very good to keep in mind as maybe a basic checklist, but I would not say these are commandments in the strict sense. These are essentially best practices have being successfully utilized for the vast majority of cross-examination questions. Right. Now, I think that is pretty much fundamentally it from me. Now, if you can just have the next slide, then these are basically the relevant statutory provisions which, basically govern the entire rigmarole of cross-examination. These are, if you can have the next slide, these are sections 135 to 166 of the Indian evidence. This is just for like basic homework or reading at home. And also, if I may just suggest a few good books, again, like I said, nothing beats practice in this area or expertise or experience. But if I may suggest a few good readings on the subject, if we can have the next slide, please. Then see these 3 books, which I personally found to be very, very useful and effective in terms of giving you a broad overview of, what this essentially is. This Francis Wellman in particular, the only difficulty is that this was written somewhere in the, I believe, in the early 20th century. So some of the text, even though there is now a 1997 version, the text and the examples may seem a bit out of touch, but it is a fascinating, insight into how cross-examination happened over the years, because a large chunk of the book is essentially reproductions or examples from actual cross-examination. So that way it's a fascinating book. And well, just to conclude, I would only say that, essentially the whole purpose, if you may have the last slide, the whole purpose of cross-examination essentially is to, as we already said, the 3 principles of control, credit, and contradict. Now, many a times we may feel that a witness is foolproof. His demeanor, his or her, their articulation, how perfectly and tightly their deposition or their examination chief has gone. But one must always remember is memory is always an adaptive process. And therefore, even the best witness, when he or she is on the stage with the relevant questions and possibly with the right strategies, there is no such thing as a perfect witness. And increasingly, it is becoming more and more evident as the days go by, because see, there always used to be this very clear distinction between preparing a witness and tutoring a witness. Now, preparation is all right. It's permissible. Telling a witness in terms of how he must address the judge, how he must respond, the overall basics, helping the witness articulate possibly, what he or she wants to say. But tutoring is completely different. Tutoring is telling a witness what the answer should be. Now that has become very rampant nowadays, and it's become much more easier in civil proceedings. Because in a criminal proceeding, like I said, since examination chief is still the norm, no matter how much you tutor a witness, when the question is put, the witness has to articulate the answer then and there. And therefore, there is going to be, some semblance of subjectivity attached to the response. But take the case of an examination in chief conducted through an affidavit. Now, this is a witness who may, in some cases I have come across, never even seen this document, a 50-page document, except on the day when he or she was signing it. Now, what happens here with such witnesses is, even the best preparation, there is a certain alienation between the text of the deposition in chief and what the witness is supposed to protect subsequently. And this is where memory, or the imperfection of memory plays a crucial role. Therefore, a lot of people actually go, in terms of why the art of cross-examination is dying. That is predominantly also because in a lot of proceedings now, we primarily go through documentation or, let's say, non-oral evidence. But ultimately, when it comes to a lot of the cases, the crunch case, I would say that in a case where you don't have such a good case, the documents are not in favor, neither are the pleadings that great, that is when, a cross-examination is the most useful. Because out of nothing, you can conjure up a case for your party. And that's how, cross-examination is really a game changer. So that's based on my limited experience so far. And so thanks everyone for joining in. So we can probably have the question answer session now, right, Rupen?
Yes, Amit. Thank you for such an informative session.
Yeah,
we have quite a few questions, so you can take one by one.
Right. Okay. Let me go to the Q&A. Right. I think the first question is from Mr. Aditya Khandelwal. So, when we create a doubt on the credibility of the witness, can we still use some issue that we were able to raise from that witness's statements, which are favorable to us? Yes, definitely. See, because when it comes to credibility, see, usually the aspect usually espoused is that a party which brings a witness is supposed to swim with that witness, right? Now, therefore, if you are able to show that a witness is not credible, then you are definitely going to be able to get that benefit from, a particular witness in terms of having been able to defeat his credibility, his or her credibility. But at the same time, the other side can't be said to, say that, oh no, my witness, is a crook or, is a complete idiot. And therefore, don't take into account what he has said. See, now in some cases, particularly in criminal proceedings, witnesses are, declared to be hostile. Now, if declaration does happen that, they are declared to be hostile, then, obviously you may try and demolish credibility, even though he or she is your witness. And maybe at that stage, you can maybe try and make an argument that the witness is completely sold off, or that, he or she has turned hostile, and therefore do not take into account anything they say in the testimony. But short of that, absolutely. Even after you destroy a witness's credibility, you are always entitled to take into account or take advantage of anything, which he or she has said, which favors your case. Right. I think the next question is, when can we re-examine the witness in a criminal case? Right. Criminal case, frankly, I have never done a re-examination, but from whatever I am aware of, in a criminal case, in a re-examination, one, of course, is when the witness turns hostile. The prosecution witness turns hostile for that. Then you are entitled to put the same questions which the other side could have put in cross-examination to your witness when you call him or her on the stage. The other element of re-examination in a criminal case, which again is not the normal procedure, is when many a times, once the entire cross-examination is over, then sometimes applications are moved subsequently by defense counsel saying that certain portions were left over. I could not, for whatever reason, deal with certain issues. Therefore, please call the witness. So in that case also, there might be, a prolonged case of, let's say, cross-examination. It's not strictly re-examination in that sense. Those are the two contexts I have come across in an appellate stage, but there might be more. How to deal with, so therefore, if I may go to the next one, right. Okay, I think this is reverse chronology. Wait. Oh no, it's correct, right? So in case of witness, defendant cannot cross-examine, what kind of questions we can ask to him, or how to pursue with him to get favorable answers, specifically in case of defense witness, an expert witness, right? Now see, then essentially again we'll have to go back to the art of an examination. That of course is not the subject exactly of this particular topic, but even examination in chief, though the general rule is that you can't ask leading questions, in certain circumstances, with the permission of the judge or let's say the concerned person, you might be able to put in a few leading questions. This is particular of cases where the aspect on which you are seeking to cross-examine is something which is relatively evident and is not in serious factual contestation. And I think that will be far more the case in the case of an expert witness, because he or she is not in that sense technically a fact witness. But again, like I said, the art of examination chief is quite different. So in the absence of any specific ability to cross-examine your own witness, you will have to depend significantly on the examination in chief. Right. How to deal with partisan witnesses? Well, like I said, the only way to deal with a partisan witness is to demonstrate that he or she is partisan, because that essentially, is what will knock the ground out from under that particular witness or his or her efficiency. Because what happens in the case of a partisan witness is the going is a bit tough, because almost everything you ask, is met either with a negative response or a response which, only seeks to block. But advantage with the partisan witness is that a partisan witness always has an inherent motive to twist the truth. Now, that is where, the real advantage of a partisan witness comes in. Because what happens with witnesses who are not partisan is that they are that way far more frank. So the danger with that is you may get answers, which will be, like extremely correct and make a lot of logical sense. But with the partisan, one way of getting out of, let's say, this entire trap is putting aspects which seem pretty evident. Now, if it is a partisan witness, naturally there is going to be inclination on the witness to disagree with everything you say. So usually which is followed is putting across aspects which seem very clear from a document, or let's say from a pleading, asking the witness about it, and then confronting the witness with that admitted fact or position, and therefore demolish his or her credibility. So there, these are various, permutations and combinations. And if you ask me nowadays, the vast majority of fact witnesses are, in that strict sense, partisan witnesses. Hello. Hi, Rupen. Are we all on here? Should I continue?
Hi,
with
Amit.
yeah.
What
All right.
we
So
can do
I think
is,
there are
since
quite a few. So I think what I can do is then almost 15 more. That I think will be a problem doing this online. What I can request is,
what we can
yeah,
do
please
is
tell me.
that that you can drop in your email ID here, and if anyone has a question, then people can directly email you if you could guide them on the email. Because it's almost above an hour, and most of the attendees have also left.
Right. So if I can just request everybody to just, put your queries in on my email. It's amitgeorge@outlook.com, and then possibly I'll try and deal with them on the email. Right. Thank you so much, all of you. Thank you, Sushrut. Thank you, Rupen. Thank you,
Thank you, Amit. Thank you for the session. I hope everybody liked it, and soon we'll be back on Monday with the new session.
Okay, great. Thanks a lot, guys.
Thank you.
Thank you so much, sir. Thank you.
Thank you.